Your Honor, Grace Broughton, appearing on behalf of the people, P80298.
Good morning, Your Honor. Sarah Kraus, P81830, appearing on behalf of James Murray. I'm sorry, there's nothing showing up on the screen as far as captions. Do I need to do something on my end?
I can see it. Ms. Kraus, if you go to the bottom of your Zoom screen,
Yes.
and there will say, you'll see something that says show captions. You just have to click on it.
Okay. It's very small, so I'm just gonna move my computer, but I have it on. Thank you.
Okay. Can you see that, Mr. Murray?
Can you see that? Can you see? Yes.
All right. So we're here today for a competency hearing. And we had two reports. We had the initial report from the Forensic Center. And then the prosecution requested an independent, which was granted. And we received a report from Dr. Shazer, a forensic psychologist, and his report on competency as well. Have both parties had an opportunity to review both of these reports?
The people have, Your Honor.
The defense has also, Your Honor.
Okay, so both reports indicate that the defendant is not competent to stand trial because of his language barriers, because he is hearing impaired and apparently does not know sign language. And both opinions of both psychiatrists or psychologists were that his ability to become competent could not happen within the statutory time frame required under Michigan law. Is that your understanding of both reports?
That is the people's understanding.
That is also my understanding, Judge.
Okay. So are the parties stipulating to those results?
The people would stipulate to those results, Your Honor. I believe that because there's no mental illness and no intellectual disability, which were found by either Dr. Thomas Shazer or Dr. Stephen Shostak, that the people could not petition for the Wayne County probate to take over. And we would stipulate to the results in this court.
Yeah, that's my understanding of the law as well. I reviewed the mental health code as well as both of these reports. And when both doctors are saying that because he doesn't have an issue that can be fixed basically with treatment, that he can, competency cannot be restored.
That is correct, Judge. It's my understanding that he is unable to assist in his defense due to his lack of expressive and receptive communication, and that there's likely no possibility that would be restored.
All right, you two can be seated if you want, if you're more comfortable. Look, this is one of the most alarming situations I've had come up, both as a defense attorney, as a prosecutor, and now as a judge. I have an individual before me who I did the swearing on this case. It's alleged that he had a minor that was essentially under his control and authority, who resided in the home with him, who looks to him for care and other types of, he's essentially a guardian of this child, right? And he took advantage of that. That's the allegation. The allegations are that this man, Mr. Murray, sexually a little girl for years. And the sex was not, I'm not justifying any level of case, was actual penetration of a vaginal sex And what's alarming to me is there's a confession. He admits he did it. And where we're at now is I have a person in front of me who was able to be married. He can clearly communicate to some degree because he's able to have a marriage, which means he was able to court somebody and go on dates and communicate effectively with them to have some sort of relationship. And then he was able to work in some capacity. He's able to be employed. He's able to pay bills. He's able to have a home. So he's competent to do everything else in the world except for stand trial a child. And I have no authority under Michigan law, and I've reviewed it, and we had a lengthy discussion in chambers. I have no authority under Michigan law to do anything about it. And it's repugnant. And I understand these are allegations, and I respect that everyone has a right to a trial, but the miscarriage of justice, you know, when we say people have a right to trial, it's not just the defendant, victims have a right to a trial. And I have a minor victim in this case who was put up with allegedly years. The trauma that comes along with that is it's appalling. And this child, according to the allegations, did what we encourage kids to do. Finally, she had the bravery to come forward and tell someone. She did exactly what we all go home and tell our kids we want them to do. If something happens to you like this, or somebody touches you inappropriately, tell. And it takes a lot of courage to do for a kid. So this little kid tells, goes to a criminal justice system that is supposed to protect a defendant's rights, but it also is supposed to protect victims and give them some sort of recourse and some sort of justice. And I have to sit here today in a robe that I waited and worked my entire life to get to say that we can't go forward on this case because a guy who understands how to pay his bills, get married, do everything else an adult does in life, doesn't understand what's happening enough here today to assist in his defense, and he gets to walk out of this courtroom with no consequences for these allegations. And this is the most difficult thing I have ever done as a judge and will likely ever do, because there is a child that is getting no justice. There is a family that is irreparably damaged. This will affect her for the rest of her life. And we all know it. There's studies on it. There's nothing that her sense of safety, I can't even fathom what I have to do here today. And this loophole in our criminal justice system that somebody who was accused of one of the most egregious crimes in our society is just going back out amongst us. He's not on a sex offender registry. Nobody's going to know that this man has been accused of these allegations. And that this young lady has absolutely no recourse in the criminal justice system. It's just unfathomable. And the idea that Mr. Murray is sitting here today and he can't understand everything, but he understood how to manipulate, allegedly, a little girl and sexuate a little girl is, it's the most extreme miscarriage of justice I've seen in my 20 years of practice. 20 years, only criminal law. I've never seen anything as appalling and egregious as what we're doing here today. So there's no way to proceed on this case. Ms. Kraus, you have a job to do, right?
Yes, Judge.
Are you asking the court to do anything?
Yes, I'm asking the court to dismiss this case against Mr. Murray, since he is not restorable to competency.
I have no choice. I have no choice under the law in the state of Michigan. Hopefully, somebody from somewhere will look at this and address it with the legislature or whoever it needs to be addressed with, because it's terrible, absolutely terrible. Mr. Murray, you go near that little girl, you'll find your way right back here. And we'll go through this all again. And you know what I'll do? I'll lock you up with no bond while the case is pending, and we'll send you for another round of exams. See if you understand anything then. Disgusting. Case dismissed.
Thank you, Judge. And there is a no contact order, Your Honor, because there is an ongoing open CPS investigation. So just as a reminder, he is still being investigated under the Child Protective Services.
That is correct, Judge. The CPS case is still open and pending at this time. It's my understanding that there is no contact order. He is not allowed to return to that residence. I would just ask the court to remind Mr. Murray of that as well, the CPS case.
Mr. Murray, you are not to go to that residence. There is an order through CPS. You're not to go near this child. Oh, you understood that. Didn't you? Yeah, you. We're on recess.